Have you ever been pulled over by a police officer and felt your heart drop? That sinking feeling when you see the flashing lights in your rearview mirror? Well, today I'm sharing legal advice from actual traffic attorneys about the exact words you should and shouldn't say when you're pulled over. These strategies could save you hundreds of dollars and keep your driving record clean. But first, let me be clear. This isn't about lying or manipulating the system. This is about protecting your legal rights and understanding how traffic law actually works. So let's dive into what lawyers say smart drivers should do when they see those blue lights. Here's the scenario. The officer walks up to your window and asks the most common question in traffic stops. Do you know how fast you were going? This is where most drivers make their biggest mistake. They either admit to speeding by saying something like, "Oh, was I going 55 in a 45?" Or they lie and say, "I have no idea how fast I was going." Both answers can hurt you in court. So what should you say? According to traffic attorney Andrew Mandel, the magic phrase is, "I believe I was going the speed limit." Why is this so effective? Because you're not admitting to speeding, but you're also not lying or appearing ignorant. You're simply stating your belief. This keeps your options open if you later decide to contest the ticket in court. Think about it from a legal perspective. If you admit you were speeding, you've just given the prosecution their strongest evidence, your own confession. If you say you don't know, you look careless and inattentive. But if you express your belief that you were following the law, you're protecting your right to contest the citation later. Remember, anything you say can and will be used against you in traffic court. Every word matters. Here's another critical tip from traffic attorneys. Never argue with the officer at the roadside. Attorney Matthew Worth puts it perfectly. To win an argument with a traffic officer, you need to be in court in front of a judge. There is absolutely no upside to arguing during the traffic stop, and there's definitely a downside. Here's why this matters. Officers have discretion. They can choose to give you a warning instead of a ticket, but only if they feel you're respectful and appreciative. If you demonstrate an attitude of entitlement or hostility, you eliminate the officer's only incentive to cut you some slack. Plus, being argumentative makes you memorable. And trust me, you don't want to be memorable. If the officer remembers you as the rude, argumentative driver, they're much more likely to show up to your traffic court hearing and testify against you with perfect recollection of every detail. So what should you do? Be polite, respectful, and cooperative. Answer questions minimally without volunteering information. Sign the ticket promptly. Signing doesn't admit guilt. It's simply a promise to either pay the fine or appear in court. Think of the roadside interaction as preserving your options. Stay calm, stay polite, and save your defense for court. Now here's an interesting strategy that actually works for many drivers: simply requesting a warning. Research shows that 36% of drivers have requested a warning, and 48% of those who asked without giving an excuse successfully avoided getting a ticket. That's nearly a 50-50 success rate just from asking. Retired Police Lieutenant Paul Petty says there's nothing wrong with politely requesting a warning if you're only going 5 or 10 miles over the speed limit. The key word here is politely. A sincere apology combined with a request for a warning can be genuinely helpful. Here's how you might phrase it. Officer, I apologize. I wasn't paying close enough attention to my speed. I understand I made a mistake. Would you be willing to give me a warning this time? However, Petty warns that officers are often assigned to specific traffic enforcement areas by their supervisors with expectations to write citations. So this won't work in every situation, but it costs you nothing to ask respectfully, and the statistics show it works about half the time. Just remember, don't combine your warning request with elaborate excuses. The data shows that asking for a warning without offering excuses is more effective than coming up with creative stories. Let's talk about what not to say, because lawyers hear these excuses constantly, and they almost never work. Everyone else was speeding too. This is probably the worst defense. Courts don't care what other drivers were doing. You're responsible for your own actions. I didn't see the sign. Ignorance of the law is not a valid legal excuse. You're expected to know the speed limits. I was late for work, or I really needed a restroom. These might generate sympathy, but they're not legal defenses for breaking traffic laws. It wasn't me. Unless you can prove your car was stolen, this excuse is going nowhere. Here's what Attorney Mandel says. If you've already given an excuse to the officer and they didn't buy it, bringing it up again to the judge probably won't help. The judge is going to lean toward the officer's testimony. Instead of relying on excuses, you need to challenge the observations of the officer or identify issues with the ticket itself. The bottom line? Skip the creative excuses. They're not legal defenses, and they often just make you look desperate or dishonest. Now let's talk about what happens if you do decide to fight the ticket in court. This is where having the right strategy makes all the difference. First, understand that there are legitimate ways to challenge a ticket. Here are some of the most effective approaches. Challenge the officer's observation. Was the officer in a position to clearly see your vehicle? In heavy traffic, could they have mistaken another car for yours? If they were pacing you from the front, could they accurately judge your speed from that position? Question the equipment. Was the radar or laser device properly calibrated? Has the officer received proper training and certification on the equipment? Radar guns can give false readings if there were other vehicles nearby, and laser technology can be affected by bright sunlight. Use the basic speed law defense. In many states, you can argue that even if you exceeded the posted limit, your speed was still safe, given the traffic, weather, and road conditions. For example, if traffic was flowing at 75 miles per hour in a 65 zone, you could argue that driving slower would have actually been less safe. Look for procedural errors. Examine your ticket carefully for mistakes. While minor errors like a misspelled name won't invalidate the citation, more significant errors about the location, time, or alleged violation might give you grounds for dismissal. Here's a powerful statistic. If the officer doesn't show up to court, there's a good chance your case will be dismissed. Many jurisdictions don't pay officers overtime to appear in court, which means they're less likely to show up, especially if they have to travel or if the ticket is for a minor violation. Even if you can't get the ticket completely dismissed, traffic attorneys say it's often worth showing up to court just to present your case. You might be able to get the fine reduced, avoid points on your license by negotiating it down to a non-moving violation, or get traffic school as an alternative. So when should you actually hire a traffic attorney? Here are the situations where legal representation is most valuable. If you're a commercial driver with a CDL, the stakes are much higher. Certain violations can lead to license revocation and job loss. With your livelihood on the line, hiring a lawyer is usually worth the investment. If you have multiple tickets in a short time, this can lead to license suspension and dramatic insurance rate increases. An attorney can help negotiate better outcomes across multiple cases. If you're facing license suspension, and this ticket would result in a suspended or revoked license, you need professional help navigating the legal system. If the ticket is expensive and the fine court costs and insurance increases will cost more than hiring an attorney, it's worth getting legal help. Here's what many people don't realize. Traffic attorneys often have relationships with prosecutors and judges. They know the local court system, they understand which arguments work in specific jurisdictions, and they can negotiate plea deals that you might not be able to get on your own. Plus, in many traffic cases, the attorney can appear on your behalf without you even needing to show up in court. That saves you time off work and eliminates the stress of representing yourself. Traffic lawyer costs vary, but the real goal is protecting your driving record and avoiding costly insurance hikes. Smart drivers know to stay polite, never argue roadside, and save defenses for court. Saying, "I believe I was going the speed limit" works well, and politely asking for a warning works about half the time. Skip creative excuses. They aren't legal defenses. consider fighting the ticket, especially if the officer might not show, and hire a lawyer when long-term costs outweigh fees. This isn't about dodging responsibility. It's about knowing your rights and protecting yourself legally. Traffic tickets can cost thousands, so stay informed and drive safely.